Introduction to the Doctrine of Separation of Power. We have discussed the example of a traditional monarch in earlier lectures. Now, to make it interesting, let's take the example one step further. The traditional ruler is under pressure from the people to adopt a modern form of government, so the people can have more freedom to do their work, travel, trade, and live their lives. The story can take two turns from this point. Either the monarchy will evolve into a system where the power is distributed to other institutions, or the monarchy will strongly hold on to the power unless there is a revolution. In the first scenario, that is a very British description of the evolution of separation of power. The separation of power will not present a very clear picture because the institutes will gradually evolve out of the influence of their parent institute. In Britain, the Crown was the prime institution, and the Parliament later became one of the top institutes as well. We will look at this bipolar evolutionary arrangement of separation of power in Lecture 3. For right now, let's go to the second scenario, where a revolution has given the people a fresh start, and they can choose how they want to govern themselves. The people can adopt a separation of power that will have a neat and pure description. All the common law institutions will be neatly separated from each other, thus minimizing influence and ensuring freedom to the people from these institutes. This scenario fits with the case study of the US, where the founders of the nation designed the Constitution with clear separation of power. The starting point of the discussion will be the work of Montesquieu. The reason for studying his work before any other is that it presents a neat and clear description of the concept. Even though his work may be too simplistic and may not be true when applied to the real functioning of common law institutes in Britain. His work is important because it has influenced the United States Constitution and is influencing the British constitutional arrangement with the passage of time. In his work, he gives us the following arguments in favor of a pure theory of separation of power. The first argument is that when legislative power and the executive powers are held by the same person or a single governmental office, there will be no liberty because the lawmaker will also be executing the law. The danger in this is that if the lawmakers make tyrant laws, they will execute them tyrannically. The second argument is that when the power of adjudication is not separated from legislative power, there will be no liberty, because the lawmaker will be passing judgments on the law they made themselves. The danger here is that the legislator can pass laws that are arbitrary and override fundamental rights, and the citizens will have no venue to challenge those laws. The third argument states that when judging is not separated from the executive power, the judge will have the opportunity to become an oppressor. This kind of work reflects the desire of the enlightened man to break away from the traditional centers of power and create a new world. The desire finds its incarnation in the form of a new start when the Revolutionary War is won. This was the case both in France and the US. Under the UK Westminster system, based on parliamentary sovereignty, the Parliament is the supreme lawmaking authority. The executive branch acts in the name of the Queen, as does the judiciary. The ministers are, in most cases, members of one of the two houses of Parliament, and the government needs to sustain the support of a majority in the House of Commons. As discussed in previous lectures, the Lord Chancellor was at the same time the sole judge in the Court of Chancery and the presiding officer in the House of Lords. Therefore, it may be seen that the three branches of British government often violate the strict principles of separation of powers. However, this arrangement does not mean that the different branches of the British government always work in the same direction. As we will study in the unique constitutional arrangement of the UK, we will use the pure theory of separation of power given by Montesquieu as a benchmark to understand how close or how far is the arrangement from the pure theory. We will also critically analyze Montesquieu's claim that if the arrangement is far from the pure theory, the liberty is undermined.